Alva Benavides, we need to talk about some DUI files that never reached the database.
Alva Benavides operated without oversight for nearly a decade as a driver safety officer at the California DMV in San Diego. Hundreds of drunk drivers depended on her decisions. Not one person checked.
I'm a hearing officer. I handle police calls all day. That's my job.
Suspensions reversed, temporary licenses with no authorization.
Every hearing has a record. Every decision is
Same
documented.
attorneys, their clients.
I rule on what comes to my desk. That isn't a crime.
6 attorneys, 12 co-conspirators, nearly a decade of stolen arrest packets, reverse suspensions, and unauthorized temporary licenses sold for cash, expensive dinners, and designer purses. By the time federal prosecutors in the Southern District of California finished documenting what Alva Benavides had done, from inside the California Department of Motor Vehicles, the woman in this footage was facing a maximum of 20 years in federal prison. And the road in front of her quasi-judicial chair was littered with drunk driving arrests she had personally erased. Quick question before we go any further. When you got your driver's license, did it ever cross your mind that one person inside the DMV could decide whether a DUI arrest stayed on your record or quietly vanished from the system? Drop a comment and tell me if you had any idea that kind of authority existed inside a building most people associate with renewal lines and number tickets. And if you are not subscribed yet, fix that now. This channel covers the cases where the people running the system are the ones breaking it, and the case you are about to hear is one of the cleanest examples of that you will ever find. Alva Benavides was born in the early 1970s in a working-class neighborhood on the south side of San Diego, California, the second of 4 children in a household where Spanish and English were spoken in roughly equal measure depending on who was at the kitchen table. Her father worked as a heavy equipment operator for a commercial paving company that handled freeway resurfacing contracts up and down the I-5 corridor. Her mother worked the front counter at a small dental office on Highland Avenue for 26 years, the kind of job where she knew every patient by their first name and could pull a chart from the rotating file rack without looking. Money was always counted. Bills were paid on the 1st and the 15th. And the family car, a beige Chevy Caprice with a cracked dashboard and an AM radio permanently tuned to a Spanish-language news station, was the household's most valuable possession. She attended Sweetwater High School in National City, where she graduated in 1989, ranked in the top third of her class. Teachers remembered her as quiet, organized, and almost compulsively neat, the kind of student who color-coded her binder dividers and submitted assignments inside clear plastic sleeves. Her senior yearbook listed her future ambition as paralegal. She enrolled at Southwestern College in Chula Vista that fall, took 2 years of general education courses, and transferred to San Diego State University in 1991, where she earned a bachelor's degree in public administration in 1994. Her first job out of college was a clerical position at a small probate law firm in downtown San Diego, filing motions and assembling exhibit binders for $43,000 a year. She held it for 19 months and left when the firm partner she worked under retired and the practice dissolved. What followed was 4 years of administrative drift. She worked the front desk at a chiropractic office in Bonita. She processed claims for a workers' compensation insurer in Mission Valley. She spent 8 months at a title company in El Cajon, pulling chains of title for residential closings. Each job paid slightly better than the last, and each one felt slightly more like a holding pattern. She told her older sister repeatedly that she wanted a government job, something with a pension, something with sick leave that accrued, something where the building you worked in would still be there in 20 years. In the spring of 2000, she applied for an entry-level analyst position at the California Department of Motor Vehicles. She passed the civil service exam on her first attempt, sat for a panel interview in early July, and received her offer letter in early August. Her start date was August 14, 2000. She was 28 years old. Her starting salary was $51,400. Her hire packet listed her as conscientious, articulate, and detail-oriented, with a supervisor's note describing her as a strong candidate for promotion into a hearing officer track within 3 to 5 years. Her first 2 years inside the department were spent at a field office in Kearney Mesa, where she rotated through registration, licensing, and audit support before being assigned to the driver safety branch in late 2002. Her supervisor's evaluations from that period describe her as reliable, calm under pressure, and possessing strong aptitude for administrative hearing procedure. She was nominated for and completed the department's driver safety officer training in 2003, a 6-week certification program covering hearing procedure, evidentiary standards under the California Vehicle Code, the mechanics of administrative per se license suspensions, and the documentation flow between arresting agencies, the DMV, and the courts. She passed the certification exam with a score of 94 out of 100. In January 2004, at age 31, Alva Benavidez was sworn in as a California Department of Motor Vehicles driver safety officer. Her annual salary at promotion was $63,800. Her caseload was assigned out of the driver safety office serving the San Diego region. She conducted her first administrative hearing on January 26, 2004, in a small windowless hearing room on the second floor of the building, with a single conference table, a court reporter's stand, and a wall clock that ran 12 minutes fast. The hearing involved a 37-year-old man arrested for driving under the influence on Interstate 805. She ruled the arrest valid and ordered his license suspended for 6 months. The order, signed in her handwriting, was filed at 2:47 p.m. that afternoon. For the first 18 months of her tenure as a driver safety officer, every order she signed went the way the file demanded. The system worked the way the public assumed it worked. A driver was arrested. The arresting agency forwarded the arrest packet to the DMV. The packet was entered into the driver safety office database. A hearing was scheduled. Benavidez or one of her peers presided. And if the arrest was valid and the breath or blood result above the legal limit, the license came off. That was the job. It was the job she had trained for, certified for, and been sworn in to perform. And for a year and a half, she did it. The driver safety officer role inside the California DMV is one of the most consequential and least understood positions in the state's traffic safety architecture. When a driver is arrested for driving under the influence in California, 2 separate proceedings begin at the same time. The first is the criminal case, which proceeds in Superior Court and is prosecuted by the district attorney. The second is the administrative case, which proceeds inside the DMV and is presided over by a driver safety officer. The two are independent. The criminal case can be dismissed, and the administrative suspension can still attach. The criminal case can result in a conviction, and the administrative suspension can still be set aside. They run on parallel tracks, and the outcome of one does not control the outcome of the other. The administrative case is built on a single document, the arrest packet. When a California Highway Patrol officer or a municipal police officer or a sheriff's deputy arrests someone for a DUI, that officer fills out a multi-part form called a DS-367, an age 21 and older officer's statement, along with the officer's sworn report, the breath or blood test results, and any supplemental incident documentation. The full bundle, the arrest packet, is then transmitted to the DMV's Driver Safety Office of Jurisdiction, where it is logged into the Driver Safety Office database. From the moment it is logged, the system runs on rails. A notice of suspension is mailed. A hearing date is set. A driver safety officer is assigned. The driver has 10 calendar days from arrest to request a hearing. And at that hearing, the driver safety officer rules on 3 narrow questions. Did the officer have reasonable cause to believe the driver was driving under the influence? Was the driver lawfully arrested? And was the driver's blood alcohol content at or above the legal limit? If the answer to all 3 is yes, the suspension attaches. 4 months for a first offense with a breath result at or above .08. 1 year if the driver refused chemical testing. Longer for prior offenses. The driver safety officer signs the order. The order is filed. The driver's license is suspended. That is the system as designed. And that is the system the public is told exists when they read about a DUI arrest in their local paper and think, that driver will be off the road for a while. The vulnerability in that system is the one nobody outside the department ever sees. Every piece of it depends on the arrest packet making it into the driver safety office database in the first place. The hearing only happens because the packet was logged. The suspension only attaches because the hearing happened. The driver only loses their license because the suspension attached. Pull the packet out before it is logged, and the entire downstream chain ceases to exist. The arrest still happened. The police report still exists at the arresting agency. The breath test result is still in the lab's records, but none of it has any administrative consequence. Because the DMV, the only agency in California that can pull a license through the administrative per se process, never knows the arrest happened. The intake clerks in 2005 did not cross-reference DMV intake against CHP arrest blotters. There was no automated reconciliation between what law enforcement transmitted and what the database received. A packet that disappeared between the loading dock and the data entry terminal disappeared completely. Alva Benavidez worked in that building every day. She knew where the packets sat between intake and entry. She knew the names of the clerks who handled them. She knew which days of the week the volume was highest and oversight was loosest. And she knew that a driver safety officer with the right access could pull a single packet out of the workflow, and nothing in the system would ever ask why. The scheme began in the late summer of 2005, 18 months after she was sworn in. The first attorney to approach her was a DUI defense lawyer with a small practice in the Hillcrest neighborhood of San Diego, who had appeared in front of her on 6 prior hearings over the previous calendar year. He had won 2 of them on procedural grounds and lost 4. He took her to lunch at a steakhouse on India Street on a Tuesday in August. He paid the check. He paid in cash. And before they left the table, he handed her a folded sheet of paper with a client's name, date of birth, and arrest date written on it, and asked her, in language so soft it could have been mistaken for a hypothetical, what it would take to make a single arrest packet not appear in her office. She did not say yes that day. She did not say no either. She took the paper. She walked it out of the restaurant in the side pocket of her purse. And 4 days later, when the arrest packet for that client arrived at the driver safety office intake from the San Diego Police Department Traffic Division, she pulled it out of the intake bin before it reached the data entry queue, walked it down to her office, and put it in the bottom drawer of her filing cabinet under a folder labeled Training Materials. It was never logged. It was never assigned a hearing. The driver, who had blown a .14 at the side of the road on Friars Road 2 weeks earlier, received no notice of suspension. His license remained valid. His record, as far as the California Department of Motor Vehicles was concerned, was clean. A week after the packet went into her drawer, an envelope containing $1,200 in $20 bills arrived inside an inter-office mailer she found on her desk. There was no return name. There did not need to be. That was the first transaction. There would be hundreds more. By the spring of 2006, she had agreements in place with 3 different DUI defense attorneys. By the end of 2008, the network had grown to 6 attorneys and 6 staff members or paralegals working under them, all referring clients into the arrangement. The mechanics evolved with the volume. For some clients, she pulled the arrest packet before it could be logged into the database, her preferred method, because it left the cleanest result. For others, when the packet had already been logged and a hearing was already scheduled, she presided over the hearing herself and ruled the arrest invalid on procedural grounds that the file did not support, setting aside the suspension that the evidence demanded. And for a third category of client, those who needed to drive immediately while their cases were pending, she issued unauthorized temporary licenses out of her own desk, signed with her own authority that the system had no record of being requested or approved. Each method served a different problem, and each method left a different kind of residue. The packet pull method left a gap, an arrest that existed at the police department but not at the DMV. The hearing set-aside method left a paper trail of unsupported procedural rulings. The temporary license method left a license in a driver's wallet that no one inside the DMV had authorized. Individually, any one of those was the kind of anomaly that a department audit could plausibly attribute to error. Collectively, clustered around the same 6 attorneys' clients over a span of 9 years, they were the shape of a conspiracy. The payments tracked the work. Cash, always cash, delivered in envelopes through inter-office mail, or handed to her at lunch meetings at restaurants in Mission Valley and Hillcrest and Old Town. Meals at restaurants she could not have afforded on a driver safety officer's salary. And gifts, designer handbags in particular, became the favored currency of the more senior attorneys in the network. A Louis Vuitton never-full from one, a Chanel flap from another, a Gucci tote in soft black leather with a gold horsebit clasp from a third, delivered to her in a shopping bag at a lunch in La Jolla in 2011 for a client whose third offense DUI she had just made disappear before the packet hit the intake bin. She admitted, in her plea agreement, to accepting more than $5,000 in cash and gifts from attorneys and their law firms over the life of the scheme. The actual total, reconstructed from the items investigators eventually cataloged in her closet, was almost certainly higher. She was careful. She did not deposit large sums into her checking account. She spent the cash on living expenses, groceries, gas, restaurants, weekend trips to Palm Springs and Las Vegas, and used her department paycheck for the rent and the utilities and the car payment, the line items a forensic accountant would look at first. She kept the designer handbags, but she did not photograph herself with them on social media. She wore the Chanel to family weddings and the Louis Vuitton to her annual reviews, and nobody at the office ever asked her where the bags came from, because the office was not the kind of office where people ask questions like that. By 2012, the scheme had become routine. The same 6 attorneys sent her work. The same 6 staff members coordinated the pickups and the deliveries, and the same patterns repeated themselves month after month. A client got arrested. An attorney called her at the office on a back line that did not go through the front desk. A name and a date and an arresting agency went into a notebook she kept in her purse, not her desk. The packet either disappeared from intake, or the hearing was set aside, or a temporary license was issued. The envelope arrived, and the work went on. For nearly 9 years, no one inside the California Department of Motor Vehicles asked her a single question about any of it. The end of the scheme did not begin inside the DMV. It began on Interstate 8 westbound in El Cajon on a Saturday night in February of 2014, when a 31-year-old man named in court records only as a victim's family member, the father of a 4-year-old girl, was killed in a 3-vehicle collision caused by a driver with a blood alcohol content of 0.19. The driver was a man with 3 prior DUI arrests in San Diego County over the previous 5 years. He had been arrested for the first one in 2009, and the second in 2011, and the third in 2013. His California driver's license was, according to DMV records, in good standing on the night of the fatal collision. He had no administrative suspensions on his record. He had never appeared at a driver safety office hearing. As far as the California Department of Motor Vehicles was concerned, none of his prior arrests had ever happened. The California Highway Patrol officer who responded to the scene that night pulled the driver's record on the in-car terminal and saw a clean history. He pulled the same record back at the station the next morning and saw the same thing. But the arrest reports for the 3 prior DUIs were sitting in the records management systems of 3 different law enforcement agencies: the San Diego Police Department, the Chula Vista Police Department, and the California Highway Patrol's El Cajon office. And the discrepancy was visible to anyone who knew to look. The CHP supervisor who reviewed the fatal collision file the following Monday was that person. He called the DMV. The DMV called Sacramento. Sacramento called the U.S. Attorney's Office for the Southern District of California. A preliminary inquiry opened inside the DMV's Internal Affairs Unit within a week. The inquiry pulled the 3 prior DUI arrest files from the 3 agencies and compared them, line by line, against the DMV's Driver Safety Office database for the corresponding dates. Every one of them was missing. The arrests existed in law enforcement's records. They did not exist in the DMV's. And the gap was not small. It was not a single missing notation. It was the entire absence of 3 separate administrative actions over a 4-year span. The inquiry expanded outward. Investigators pulled the calendar of every driver safety officer, assigned to the San Diego region between 2009 and 2013, and cross-referenced it against the arresting agency's records for that same period. They were looking for patterns, clusters of DUI arrests that had been transmitted but had never appeared at the DMV, or that had appeared and then resulted in hearings where the suspension was set aside without obvious cause. The pattern, when it emerged, pointed in exactly one direction. The missing files clustered around the calendars of one driver safety officer, and the suspension reversal anomalies clustered around the hearings of that same officer, and the attorneys representing the drivers in those cases clustered into a set of 6 recurring names. The names appeared again and again on year after year of files, in combinations that random chance could not explain. By late March of 2014, the matter was no longer an internal DMV inquiry. It was a federal public corruption investigation. The U.S. Attorney's Office for the Southern District of California opened a grand jury investigation. The Federal Bureau of Investigation was assigned, and a confidential informant, one of the paralegals from one of the 6 attorney offices, who had been the one physically delivering the envelopes for nearly 4 years, was approached, flipped, and agreed to cooperate. For the next 4 months, every payment, every meeting, every phone call between the paralegal and Alva Benavides was recorded. The case file built itself. The investigation that the U.S. Attorney's Office assembled between March and August of 2014 was a documentary case at its core. The federal prosecutors did not need to prove what was in Alva Benavides's head. They needed to prove what was in the files and what was not. And the evidence on both sides of that ledger was overwhelming. From the arresting agencies, investigators obtained the complete arrest packets for every DUI arrest within the San Diego region between January 2005 and August 2014, 11,473 cases. From the DMV's Driver Safety Office database, they obtained the corresponding intake logs for the same period. The cross-reference identified 142 arrests that existed in law enforcement records but had never appeared in the Driver Safety Office database. Of those 142, 91 were attached to clients represented by one of the 6 co-conspirator attorneys. The remaining 51 were distributed across hundreds of other law firms. The cluster was not random. It was mathematically impossible to be random. The hearing records produced a second cluster. Investigators pulled every administrative per se hearing presided over by Alva Benavides between 2005 and 2014 and reviewed the orders she had signed. Of 2,318 hearings, she had set aside the suspension in 207. Of those 207 set-asides, 146 involved clients represented by the same 6 attorneys. Her set-aside rate for clients of the 6 co-conspirator firms was 63%. Her set-aside rate for all other firms combined was 3.1%. The disparity was not a question of interpretation. It was a question of corruption. The temporary license records produced a third. Investigators identified 73 temporary licenses issued out of the San Diego Driver Safety Office between 2005 and 2014 that did not have a corresponding authorization in the system. Licenses that had been printed and signed and handed out, but that no supervisor had approved and no database had recorded as approved. All 73 carried Alva Benavides's signature. All 73 had been issued to drivers who had been arrested for DUI. And in every single case, the driver had been represented by one of the same 6 attorneys. 3 clusters, 310 total irregularities, 1 driver safety officer at the center of every one of them. The consensual recordings the cooperating paralegal made between April and August of 2014 closed the case. On a recording made on April 22, 2014, at a restaurant in Mission Valley, the paralegal handed Benavides an envelope containing $900 in cash. On the recording, she opened it under the table, counted the bills with her thumb, slid it into her purse, and said, "Tell him the hearing is on the 14th. It will be fine." On a recording made on June 9, 2014, the same paralegal delivered a Louis Vuitton handbag in a shopping bag at a parking lot meeting in the Gaslamp Quarter. On the recording, Benavidez asked which client it was for, was given a name, repeated the name back, and said, "The packet is already gone. He doesn't need to come in." On a recording made on July 30th, 2014, 12 days before her arrest, she accepted $300 in cash for issuing an unauthorized temporary license and was overheard saying, "This one is easy. He's already on my schedule." The cash she could explain away as a personal loan if she was forced to. The handbag she could explain away as a gift. The recordings, her own voice, naming the clients, confirming the disappearances, scheduling the favors, were the case. We are about to get to the moment the federal agents walked into the driver safety office and took her out. Before we do, if you have made it this far, take a second and subscribe. We cover the cases that mainstream news ignores, the ones where the system gets sold from the inside, and the next one on this channel is going to be worse than this one. I promise you that. The arrest came on the morning of August 11th, 2014, at the California Department of Motor Vehicles Driver Safety Office, where Alva Benavidez had reported to work for the previous 11 years. Federal agents from the FBI's San Diego field office, accompanied by 2 investigators from the DMV's Internal Affairs Unit, arrived at the office at 8:47 a.m., 17 minutes after she had badged in and 40 minutes before her first scheduled hearing of the day. They did not announce themselves at the front counter. They walked past the reception window, through the secured door, down the carpeted corridor to the back of the building, and stopped at the open door of her cubicle. She was at her desk. There were 2 arrest packet folders in front of her, both belonging to clients of the co-conspirator attorneys, both scheduled for hearings that morning. Her coffee mug, the one with the California state seal, was half full. She was wearing a navy blazer and reading glasses. She looked up when the lead agent stepped into the doorway. The agent's name was Special Agent David Cortez, FBI San Diego. The conversation that followed was brief. "Alva Benavidez?" "Yes." "I'm Special Agent Cortez with the FBI. This is Agent Mitchell. We have a federal arrest warrant for you. I need you to stand up, step away from the desk, and place your hands where I can see them." She did not move for several seconds. She set the pen she was holding on top of the open folder. She removed her reading glasses and set them on the desk beside the pen. She closed the folder. "On what charge?" "Conspiracy to accept bribes, ma'am. Please stand up." She stood. Her left hand reached, instinctively, toward the desk drawer where she kept her purse. The same drawer where for the better part of 9 years, envelopes of cash had been deposited and small folded sheets of paper with client names had been retrieved. "Step away from the desk, ma'am." She stepped back. The second agent moved past her and put a hand on the drawer, holding it closed. The conversation that followed lasted under a minute, and the only line of it that anyone in the office heard her say, before she went silent and asked for a lawyer, was the line that everyone within earshot remembered later. "I want to call my attorney." "You can do that at the federal building, ma'am. Turn around, please." She turned. Her hands went behind her back. The metal of the cuffs closing around her wrists made a single dry sound in the carpeted quiet of the office. 2 of her co-workers were standing at the doorway of the next cubicle. A third was standing in the corridor. No one said anything. The lead agent took her left elbow. They walked her, in her blazer and her flat shoes, the 87 feet from her cubicle to the back service door of the building, past the reception window where she had badged in less than an hour before. The black government sedan was parked in the loading zone. They put her in the back seat. The door closed. It was 8:53 a.m. The hearings she had been scheduled to preside over that morning were reassigned by 10 a.m. to 2 other driver safety officers, neither of whom had ever met any of the clients whose packets were still sitting open on her desk. The federal indictment, returned by a grand jury in the Southern District of California, charged Alva Benavidez with 1 count of conspiracy to accept bribes in violation of federal public corruption statutes. The indictment laid out the 9-year arc of the scheme in granular detail. The 6 attorneys, the 6 staff or representatives, the methods, stealing arrest packets, setting aside suspensions, issuing unauthorized temporary licenses, and the consideration she had received, more than $5,000 in cash and gifts, including designer handbags. The case was assigned to U.S. Magistrate Judge Karen S. Crawford for the entry of plea. Benavidez retained a defense attorney out of downtown San Diego who had built his practice on federal public corruption cases. He was not one of the 6 attorneys named in the indictment. He read the case file, he listened to the recordings, he reviewed the database analysis, and he advised her, within 72 hours of her arraignment, that going to trial against this volume of documentary evidence and her own recorded voice was not a defense. It was a longer sentence. He recommended a guilty plea. She accepted the recommendation. On the date set for entry of plea, in the federal courthouse on Front Street in San Diego, Alva Benavidez stood before U.S. Magistrate Judge Karen S. Crawford and pleaded guilty to 1 count of conspiracy to accept bribes. The plea agreement, filed publicly in the docket, stipulated that between 2005 and August 2014, she had entered into agreements with 6 attorneys and 6 of their staff or representatives, that she had used her position as a California DMV driver safety officer to steal arrest packets before they could be entered into the database, to set aside license suspensions through her hearing authority, and to issue unauthorized temporary driver licenses to drivers arrested for DUI, and that in exchange she had accepted more than $5,000 in cash and gifts, including meals and designer handbags. The statutory maximum penalty for the offense was 20 years imprisonment. At the change of plea hearing, the assistant U.S. attorney handling the case read into the record the statement of the CHP supervisor, whose initial referral had opened the investigation. A statement that did not name the 4-year-old girl, whose father had been killed on I-8 in February of 2014, but that referenced, without elaboration, the public safety consequences of the defendant's conduct. The defendant did not just accept bribes, the prosecutor said. She sold the integrity of a public safety system. Every DUI arrest she erased was a driver who had been caught impaired and was put back on the road. The system was built to protect the public from exactly that. The defendant took money to defeat it. The case against the 6 co-conspirator attorneys and against the 6 staff members and representatives who had served as the network's couriers and coordinators proceeded on parallel tracks. The cooperating paralegal whose recordings had built the case against Benavidez was the central witness in each of those cases, and her cooperation was the lever that turned the rest of the network. Several of the attorneys entered their own guilty pleas in the months that followed. Disciplinary referrals to the State Bar of California were initiated for every attorney named in the indictment. The California DMV, for its part, instituted a department-wide audit of every administrative per se hearing, presided over by every driver safety officer in the San Diego region for the previous decade. The audit identified procedural irregularities far beyond the ones tied to Benavidez. None of them rose to the level of criminal conduct. But the broader picture, that a quasi-judicial function inside the DMV had been operating without meaningful oversight for years, became part of the public record. The 142 DUI arrests that had been erased from the database during Benavidez's tenure could not, in any meaningful sense, be put back. The administrative per se statute carries a fixed timeline. The suspensions that should have attached at the time of arrest could no longer be retroactively imposed years later. The drivers whose records had been laundered through Benavidez's drawer in 2007 and 2008 and 2009 had, in many cases, gone on to renew their licenses, drive without incident, or, in some cases, be arrested again. The system the public assumed existed had not existed for those drivers. And the cost of that, the actual cost, measured in collisions and injuries and lives, was a question that the federal courtroom in San Diego was never asked to answer, because the federal statute under which Benavidez was charged did not require that question to be asked. Alva Benavidez was, at the time of her plea, 42 years old. She had spent 14 years as an employee of the California Department of Motor Vehicles. She had presided over more than 2,300 administrative hearings. She had earned a state pension that, at the moment of her arrest, vested in 23 months. Under California public employee statutes, a conviction for a felony committed in the course of public employment forfeits the pension contributions accrued during the period of misconduct. Her pension, for all practical purposes, was gone. Her career, in any field that required a background check, was over. She faced a maximum statutory penalty of 20 years in federal prison. The sentencing hearing in her case, at the procedural posture this report covers, had not yet occurred. The plea was entered. The factual basis was on the record. The exposure was 20 years. What is on the record, and what does not change, regardless of the sentence eventually imposed, is the shape of what she did. For nearly a decade, inside a public agency built to keep the most dangerous drivers off the road, Alva Benavidez sold the keys. She took cash and meals and designer handbags in exchange for stealing arrest packets, reversing license suspensions, and handing unauthorized temporary licenses to drivers who had been arrested for driving impaired. The drivers she helped did not deserve clean records. The roads they returned to did not deserve them. And the system that was supposed to stand between them and the next collision, the quasi-judicial chair she sat in 8 hours a day for 11 years, did not stand at all. It bent every time in the direction of whichever envelope had landed on her desk that week. The case against her closed the way the scheme had been built, on paper. The arrest packets she had stolen were not in the database, but the arrests had still happened in the world, and the gap between the two was the exact shape of her crime. That was the smoking gun. That was always the smoking gun. A DUI that the DMV never recorded is not a DUI that did not exist. It is a DUI that someone made disappear. And in San Diego, between 2005 and 2014, that someone had a name, a badge, a hearing room chair, and a closet full of designer purses. This case was disturbing. But the case on the right-hand side is even more outrageous. The kind of betrayal you have to see to believe. Click it now.